United State versus Barisone. Charge conference, the indictments 1912-00999-A. May I have appearances of counsel?
Good morning, Your Honor. May it please the court, Christopher Shellhorn for the state.
Good morning, Your Honor. Alexander Bennett on behalf of the state.
Edward Belinkis here on behalf of Michael Barisone.
And Christopher Deininger here on behalf of Michael Barison.
All right. Morning, everyone. Mr. Barisone is present. Wearing a blue shirt and a blue and light blue striped tie. All right, this is a charge conference in this case, so let me first run through. I have a rough draft, very rough draft of the charge, so I'll run through for everyone my initial thoughts on the charge, and then I'll hear from counsel regarding any additions.
Judge, if I may, I just wanted to put on the record that I make a motion at the end of the case. I don't believe there's sufficient grounds to present the case to the jury. So,
Okay.
just so the record's
All right,
clear.
understood. Anything you want to say with regard to that, Mr. Shellhorn?
No, Your Honor.
All right. I think the record speaks for itself. The motion will be denied. There is sufficient evidence, as I said, after the completion of the state's case and taking into account everything that's been presented. I think there is very clearly sufficient evidence for counts 1 and count 2 charging attempted murder, and counts 3 and 4 charging possession of a weapon, namely a handgun, for an unlawful purpose. The motion will be denied. All right. With regard to the charge, most of these are from the model jury charges. Or relate general information, the nature of the indictment itself, presumption of innocence, burden of proof, reasonable doubt, function of the court, judge's questioning, function of the jury, direct, and then that's the first part. Now the second part of the instructions deals with specific evidence. I give the standard charge on direct and circumstantial evidence, the standard charge on credibility of witnesses, the standard charge false in one, false in all, standard charge on statements of the defendant, although I did, the standard charge requires the court to address some specifics so the jury knows what the court's talking about. So as I recall, there were statements from, related statements by Corporal Derek Heimer relating, the defendant stated at the scene, I had a good life. Repeatedly stated, I had a good life. Also, police officer Hensley testified that while defendant was in an ambulance, he stated, quote, "Is this real? I need to wake up." Was his testimony that was repeated, Mr. Shellhorn, if you recall?
My recollection is that it was, yes,
All
Judge.
right. Is that your recollection, Mr. Belinkis?
Yes,
All right.
but that was his testimony.
And Detective Gould testified at the hospital while the defendant was in the ICU unit. He heard the defendant stated, and I'm going to use the term in sum and substance because that's, the detective didn't use that term, but he didn't relate it word for word like the other two witnesses. So in sum and substance, he said, they destroyed my life over the past 6 months. I had a good life. They took it all away, and that he was sorry. And then the charge relates to consideration of circumstances, facts as how the statement was made, specifically about the standard charge directs reference to Miranda, so I will indicate that Hensley testified he advised the defendant of his Miranda rights from a card he carried. Officer Hensley testified the defendant verbally acknowledged his Miranda rights but did not recall whether defendant indicated he wished to speak to the officer. There was also testimony adduced from various witnesses regarding the defendant's physical injuries and mental status at the time. and I go on the end of that particular charge, if after consideration of all these factors, you determine the statement was not actually made or the statement is not credible, then you must disregard the statement completely. If you find the statement was made, statements, you find the statements were made, and that part or all of the statements are credible, you must give what weight you think appropriate to the portion of the statement you find to be truthful and credible. The defendant's election not to testify, I'm assuming you want that, Mr. Belinkus? Mr. Deininger? Okay. Then there are limiting instructions. I think one of the witnesses did reference the defendant being in jail. So, just out of an abundance of caution, I'm going to include that charge unless I hear any objection.
No, I think it wasn't explicitly really talked about, but it was.
No, the experts didn't do that.
Yes.
But, and I think it may have been, I'm trying to remember, I'll go through my notes over the weekend, but I do recall a witness said it. It wasn't specifically asked, but it came out. It may have been Dr. Simmering that said it.
My recollection is that it first came out with one of the witnesses that the defense called
Yeah.
who works at the jail.
Yes.
And indicated.
That's right, the psychiatrist at the jail.
Yes, and then it did come up through the experts, I think it was Dr. Simmering and Dr. Hassan,
Right.
mentioned reviewing jail records or something
Yes,
of that
yeah.
nature. But I think it would just make the record clearer, Judge.
I agree.
All right, so I'm just going to say, during the testimony of certain witnesses, I'm not planning on indicating which witnesses unless you want me to.
I don't see a need for that, Your Honor.
You want me to mention the specific witness, or just a general reference? All right.
General reference.
During the testimony of certain witnesses, they may have made reference to the fact that information was obtained from the defendant while he was in custody at the Morris County Jail, and that's specifically referring to the jail psychiatrist. The fact that the defendant was detained in this facility at some point is irrelevant and should play no part in your consideration of this case. You may not use this evidence in any way to infer that the defendant is guilty of the charges simply because he may have been in custody at some point in the past. I don't want to reference that he's still in custody, that would only emphasize the point, so. And I think I forget the gentleman's name who testified, the jail psychiatrist. I think he said it was shortly after the incident. So that's why the wording is as it is. I don't want to tell them that he's currently in jail, but at some point, that's why I use the phrase "at some point in time." Is there any objection to the wording, counsel?
No, Your Honor.
I'm not sure about at some point, if I would just say at any, there's a reference with regard to him being in jail, and then go on from there. So, at some point, to me, indicates that he was let out, or, again, just.
Well, I wanted to avoid speculation that he's either in jail or out of jail, and why was he let out, or why is he still in jail? That's why I said at some point to try to
To me, I think.
obfuscate the issue. But if you want it some other way, you tell me what you want and I'll put it
I
in.
just want at some point out.
And whether he's in jail or not currently is not an issue.
Correct.
I mean, it's not evidence one way or the other. And obviously shouldn't be commented on that during summations. All right, so I'll just say the fact that the defendant was detained in this facility is irrelevant and should play no part in your consideration of the case. You may not use this evidence in any way to infer that the defendant is guilty of the charges simply because he was in custody. Because I say again, he may have been in custody at some point in the past. You want me to take that out and just say to infer the defendant is guilty of the charge simply because he was in custody.
Yeah.
All right. All right, the limiting instruction, use of drugs by Lauren Kanarek and Robert Goodwin. I reference that, again, without specifics as to the witnesses because there were multiple references to it. Having used drugs in the past, the testimony was admitted by the court for a limited purpose. Testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering, Dr. Hassan. I'm not sure Schlesinger mentioned it.
I don't recall it coming up when he testified, no, Judge.
All right. Or for assessing the value of the doctor's opinions that are dependent or rely on this information. You may not consider this testimony for any other purpose. You should not consider the testimony as substantive evidence relating to the guilt or innocence of the defendant, or consider it as reflecting the bad character of Lauren Kanarek or Robert Goodwin. Any objection to that charge?
No, Judge.
No.
Limiting instruction with regard to the prior criminal history. You have heard testimony regarding the purported and unverified prior criminal history of Robert Goodwin and Lauren Kanarek that the defendant received from private investigator Joseph. It's Blattler, right? That was the PI,
Yeah,
Joseph Blattler.
I believe that's true, Your Honor. He received similar information from Kat Parkinson, but you ruled it out.
Defendant alleged this information had an impact on his state of mind. I'm not sure I want to insert that in there. That was in your request. I'm not sure because saying the defendant alleges, sort of comments in a roundabout way. He hasn't alleged anything directly because he didn't testify. So I don't want to, I'm a little concerned with that reference.
Could I hear the rest of the
Yes.
the court's charge, Judge? Thank you.
All right, so defendant alleged, I have it, putting it in brackets because I'm not sure. I instruct you that this testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering and Dr. Hassan, or for assessing the value of the doctor's opinions that are dependent or rely on this information.
Would Your Honor consider using the defense alleges instead of the defendant alleges?
Yeah, I could do that. I like the reference to the defendant's state of mind because that's what
Yes.
we're talking about here. You have any problem
No, Judge,
substituting defense for defendant?
No, I think that makes sense. That was why I had suggested that language, less to put some onus on the defendant, but more.
Right,
for the purpose the jury
because
can
I think
consider.
it, from the outset, it focuses the jury on the fact that the issue is the defendant's state of mind.
Yes.
And that's why it was admitted. So, all right, it'll read, after the introductory line from the private investigator Joseph Blattler, the defense alleges this information had an impact on defendant's state of mind. The defense alleges this information, I could say, had an impact or affected.
It may be more consistent with the rest of the jury charge on insanity to say affected.
Yeah. The defense alleges this information affected defendant's state of mind. I instruct you that this testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering and Dr. Hassan regarding defendant's state of mind, or for assessing the value of the doctor's opinions that are dependent or rely on this information. And I go on to explain, under the rules of evidence, a jury may consider a witness's criminal conviction in determining the credibility or believability of that witness. However, there is no evidence that Lauren Kanarek or Robert Goodwin have criminal convictions. You must not consider testimony related to the alleged prior criminal history as affecting the credibility of Lauren Kanarek or Robert Goodwin, nor may you consider it as substantive evidence related to the guilt or innocence of the defendant. The only relevance of the evidence is the extent to which you find it affected the mental state or mental condition of the defendant. All right with that, Mr. Shellhorn?
Yes, Your Honor, thank
All
you.
right, Mr. Blinkus?
Yes.
And I give a limiting instruction on testimony related to Ms. Kanarek's owning a firearm. That instruction reads, you have heard reference to Lauren Kanarek owning or possessing a firearm. This testimony was admitted by the court for a limited purpose. This testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering, Dr. Hassan, and I think Dr. Schlesinger made reference to it.
I believe he did make reference
Right.
to that, Judge.
Regarding the defendant's state of mind or for assessing the value of the doctor's opinions that are dependent or rely on this information, you may not consider this testimony for any other purpose. Should not consider this testimony as substantive evidence related to the guilt or innocence of the defendant or consider it as reflecting the bad character of Lauren Kanarek.
No objection.
No objection.
All right, and then the last limiting instruction would be on the mental health diagnosis. I'm not sure, was there any specific testimony about the mental health diagnosis? I know there was reference on cross-examination to some of the postings, multiple personalities. I wasn't gonna get that granular with regard to the charge, just generally. You have heard reference in certain testimony regarding the a mental health diagnosis. Well, I don't know. That sounds like there was a formal diagnosis, and I'm not sure there was.
I agree with the way it came out, Judge. Obviously, there was more information in the reports that didn't come out during
Right.
trial. So when I submitted that, I didn't know what the testimony would be, but I would agree that the crux of it was the post. And I would suggest that it's not appropriate to give the limiting instruction based on what was in that post.
But, Your Honor,
So you don't want it at all?
That's fine, no.
Your Honor, we have a limiting instruction that I believe touches upon this. If I could approach and give you a copy, the word "it" in that instruction refers to, we believe, evidence like this. I've already shown it to Mr. Sheldon.
What do you want this for, specifically?
We want a limiting instruction so that the jury understands what could be considered substantive evidence relating to guilt or innocence, rather than something that's just tending to support or not support an expert's ultimate conclusion. And also that they be instructed about the probative value of opinions when there is independent proof. I don't believe there's an objection from Mr. Shellhorn, except we need to flesh out the word "it."
I think my
But
understanding.
I guess my question is, we have a number of limiting instructions here.
My understanding here, Judge, was that this related more to the defendant's statements, and that the defendant's statements to the doctor should not be considered as substantive. Not the statements that were
Right.
admitted
There's,
substantive.
yeah,
Agreed.
But there are other statements he made that came out that should not be considered substantively. I think, and I assume that counsel will not make that argument in closing, that the statements he made to the doctor are substantive, but just that those are offered for the effect that it had on his state of mind, as the doctors opined about that.
right. So there's a part of the standard expert testimony charge. So you don't want the mental health diagnosis charge?
Correct.
All right. Do you have any objection to having that excluded?
No, Your Honor.
All right, so after those, then I give the standard expert testimony charge. And I have the expert witnesses, I want to identify them specifically. It's Detective Andreas Zaharapoulos,
Zaharopoulos.
I'm gonna have to practice that over the weekend, Mr. Shellhorn. Couldn't you come up with an expert with a different last name, easier to pronounce, a shorter number of syllables, perhaps?
You'll have to talk to Sheriff Gannon about that, Judge.
Like something like William Stitt, I can handle. Zaharopoulos, I can tell you right now, I'm gonna stumble over that.
Theopolis is a common name
I know,
ending, right?
I know, that's why,
It's the
yeah.
beginning that's.
It's the Zaharopoulos.
Yes, Your Honor.
Judge, everyone calls him Detective Z, so I don't think
Alright.
he'd be offended if you wanted to refer to him as Detective Z.
Well, if I stumble over it more than once, that's when I'm gonna fall back on Detective Z. William Stitt, Stephen S. Simmering, MD, Charles S. Hassan, PhD, and Louis B. Schlesinger, PhD. We're called as experts. Anyone else? Did I miss anyone?
No, Judge.
I don't think so, Your Honor.
And I'll call, it's Dr. Hassan and Dr. Schlesinger, and then I'll
Your Honor, I
mention the
actually-
PhD at the end. So we'll go through that. There's a standard charge, but then there's a limiting instruction regarding the hearsay statements of the defendant. And it's similar to what counsel gave me.
Here-
And it says, you have heard reference to alleged statements made by the defendant in the course of psychiatric examinations. You should not consider these hearsay statements as substantive evidence related to the guilt or innocence of the defendant or for the truth of the matter asserted by the defendant in the statement. Rather, I instruct you to consider these statements only for a limited purpose of explaining or supporting the conclusions of Dr. So-and-so and so-and-so, or assessing the value of the doctor's opinions. So you would rather, instead of that instruction, you want the court to provide this limiting instruction?
Yes, Your Honor.
Okay. Do you have any objection to that?
I don't see an issue with what's in the standard charge, but I think this essentially says, at least if it's tailored to indicate that it's talking about the defendant's statements. I mean, I think it still
let me
has
just-
to relate back to the hearsay aspect. I think the issue I have with the second paragraph on what's been provided is that it talks about the opinion hinging on the truth of the matter asserted. And I don't know that there's anything that the doctors testified to that hinged on the truth of the matter. It was just on things that.
Right, I'm not sure there was anything that hinged on the truth. It's not, it goes to his state of mind. It's whether he believed it or not whether it was true or not. And that goes, that's the same as any other state of mind. You know, statements are let in not for the truth of the matter asserted, but because of the impact they had on the hearer. And if they took some action as a result of hearing that statement, for instance, it would still come in, but not for the truth of the matter. So I'm not sure the opinions of any of the doctors relied on the truth of the matter asserted.
Well, Your Honor, go ahead.
Judge, I think with regards to any evaluation, when an individual tells the doctor certain things, if there's independent verification that he is able to look at and document, I think he takes that, and I think the doctor's indicated, takes that into consideration with regards to things the person is telling him, and whether or not he should believe him. All the doctor says, they really don't take the defendants, what they tell them at face value. You have to review the discovery, see what is in there, and if it can be documented that what he is telling you the truth, I think that has an impact on whether he believes him, whether he's being honest, and so forth. So I think that's a general statement.
Well, it's the truth of the matter.
I think as I look at
Asserted,
this,
it's,
Judge,
you can
too
view it a
general.
number of different ways. That's, and part of my concern with this is the first part, the statements, because it reads, you have heard reference, alleged statements made by the defendant in the course of psychiatric examinations. then I would put, those statements should not be, not instead of it, we're referring to those statements. Those statements should not be considered by the jury as substantive evidence related to the guilt or innocence of the accused, but only as evidence tending to support the ultimate expert conclusion of the psychiatrist on the question of insanity. So, a lot of this is contained in the standard charge, because it says, it is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent on, and is no stronger than, the facts on which it is based. In other words, the probative value of the opinion will depend on whether from all the evidence in the case you find that those facts are true. You may in fact determine from the evidence in the case that the facts that form the basis of the opinion are true, or not true, or true in part only. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts alleged. That's essentially what's laid out in this limiting instruction. And that's the standard charge, so I'm not inclined to deviate from that.
I agree with that.
I mean, I could put in the first part, certainly. Which is essentially in there already. Yeah, I think the second part is covered by the standard expert charge. And that's not just to the psychiatrist, but for any of the experts. All of their opinions are only as good as the facts upon which they form their opinion. All right. Now, there's an optional charge concerning compensation of experts. I'm not sure.
That was never brought up, Jim, so I guess that not be included.
I don't think it came up with any of the experts.
All right, and I'll charge testimony of character witnesses.
Yes, Your Honor.
And that's a standard charge. I don't have their names specifically. I have to review my notes, but what's your recollection of who the character witnesses were?
Well, Your Honor, I believe the testimony of that nature certainly came in with Boyd Martin, B-O-Y-D Martin, Philip Dutton, that's D-U-T-T-O-N, Allison Brock, and if I'm not mistaken, to some extent, Stephen Tarshis. I don't remember clearly whether he went beyond, for example, I believe I asked him, and my recollection's foggy, but I believe I asked him whether or not Michael was ever committed harm to a horse.
Not really character evidence, though. It's really, true character evidence is reputation, opinion, or a criminal conviction, which doesn't apply here, but it's really just true character evidence is reputation or opinion.
In my mind, Judge, Mr. Dutton and Mr. Martin were both certainly character witnesses. I think Ms. Brock kind of blended between a character and a fact witness.
He did indeed.
And I don't recall Mr. Tarshis really, he certainly talked about his knowledge of the defendant, as did a number of other witnesses. But I think at that point, we start getting into, we heard that testimony from Ms. DeFranco, from Ms. Dancer, from Mr. Hardin, from Ms. Gray. think Ms. Cook-Gibbs gave some kind of testimony along those lines. But I don't think they were true character witnesses in the sense that Dutton, Martin, and Brock were.
Your Honor, I'm satisfied if we use Dutton, Martin, and Brock, Your Honor.
All right.
I'd be okay with that.
Yeah, I don't think Cook-Gibbs was really a character witness.
And just so I'm clear, Judge, I don't either. I was just using her as an example of another witness who testified to sort of reputational information that she was aware of.
Not even sure Brock gave sufficient character testimony. At least not according to my notes. Testified she lived in Florida, Waxahachie, Florida. Talked about being in dressage, and being an equestrian for 25 years, member of the 2016 Rio Olympic team, received a bronze medal. Mr. Barisone was the coach. She met him in 2002. And Justin Harden as well, began to train with Mr. Barison. Saw him here and there, knew Mr. Barisone as a close friend. August, she was in Florida. She received a phone call from Jamie Dancer, spoke to Ms. Dancer for a couple of minutes. As soon as she hung up, she called Mr. Barisone, concerned that Mr. Barisone would kill himself, and then spoke to Mr. Barisone. Said he was upset and sobbing. I don't really see too much character testimony. Do you have anything different, Mr. Shellhorn or Mr. Deininger?
That's generally consistent with my notes, Judge.
Yeah, it's consistent with my notes.
All right. So I don't consider her to be a true character witness. She may have said nice things about Mr. Barisone as a coach and things like that, but that's not really truly character evidence under the rules. Certainly Mr. Dutton was. And Boyd Martin certainly was. I think it's just those two would be characterized as character witnesses. And that's just the standard charge. And then we get to the third part of the instructions. Anything else we need with regard to specific types of evidence?
I don't believe so, Judge, not from my perspective.
Mr. Belinkus, anything else?
No, Judge.
All right, so the third part goes through the specific portions of the criminal code that the jury has to apply to the facts to determine whether the state has proven the charges beyond a reasonable doubt. There's a standard charge when there are multiple charges, as there are here, so I'll give that charge. And I'll lay out attempted murder, counts 1 and 2. And there's a standard charge. I'll read the counts of the indictment at that time. Relevant statutes, and then get into the specifics of what has to be proven. And I'll just follow the standard charge. I'm not going to repeat it twice, obviously, because counts 1 and 2 are the same. I'm going to refer to counts 1 and 2. And then when I get into the specifics, state must prove the following elements beyond a reasonable doubt. First, it was the defendant's purpose to cause the death of Lauren Kanarek, as alleged in count 1, and Robert Goodwin, as alleged in count 2. And secondly, the defendant purposely did or omitted to do anything which under the circumstances as a reasonable person would believe them to be is an act or omission constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victim. I'll define purposely. Define a deadly weapon is included in the charge as well. And the second element is that the defendant did or omitted to do anything. I know you charged Mr. Shellhorn did or omitted to do, but I'm not sure the omitted to do serves any purpose other than perhaps confusing the jury when they hear it.
And Judge, as you're even saying this right now, I would have no objection to removing any language about omitting to do anything. I don't think that applies to
Well,
the specific case.
I can't obviously remove it from the indictment because that's what's charged, but,
But from the charge, I don't have any objection to that.
so anywhere where references omitted to do anything or omission, I'm gonna strike. Any objection?
No, Your Honor.
No. Mr. Belinkus, any objection?
No.
All right. Then I'll get into counts 3 and 4, and again, I'll do the same thing, so I don't have to repeat myself.
Judge, before you move on to the other counts, when I had submitted a draft jury charges to the court, I had indicated a possible lesser included offense of aggravated assault.
I know, but I plan on giving that. I'm just not sure where in the charge I should give it. Because I'm charging insanity, obviously. If the jury accepts that the defendant was legally insane, they wouldn't consider any lesser included offenses. They're not gonna say, as to count one, I mean, if they find that he's insane, he's gonna be insane on count 1, 2, 3, and 4. They're not gonna pick and choose. So I'm not sure they would even get to a lesser included offense if they believe that Mr. Barisone is insane.
Well, Judge, I had left on your bench, as well as given the council this morning, a proposed verdict sheet that I basically just modeled after what was on the model verdict sheet on the judiciary's website. But I think that, at least the way I'm proposing it should be laid out on the verdict sheet, would be that the jury would consider whether the defendant is guilty or not guilty of the crime of attempted murder, just using charge 1 as an example. And then also not guilty by reason of insanity would be listed there. If the jury finds the defendant guilty of attempted murder, they move on to the next charge. If they find him not guilty by reason of insanity of that charge, they move on to the next charge. But if they find him not guilty, then they would move on to consider a lesser included offense
Of aggravated assault.
of aggravated assault.
Judge, with regards to his verdict, I would ask that not guilty by reason of insanity be first, then not guilty, and then guilty. With regards to lesser included offense, I don't think they're appropriate.
Well,
So at least that-
my thought was, why I thought aggravated assault might be appropriate. Because if the jury does not believe Mr. Barisone was legally insane at the time of the commission of the offense, that does not mean they can't consider his mental state in determining whether he acted purposefully or knowingly in committing the crime. In other words, they may find he didn't meet the threshold for legal insanity, but he did have a diminished capacity because of the stressors, the circumstances, his depressive state. And the jury may find the testimony and the circumstances didn't arise to legal insanity, but they recognize that he was operating with a diminished capacity, which may prevent him from purposely or knowingly or having a conscious object to commit the murder of Lauren Kanarek and Robert Goodwin, such that they would consider a lesser charge of recklessly attempting to cause the death or serious bodily injury to Lauren Kanarek or Robert Goodwin.
I've considered that too, Judge. I think that there's two parts to that question, though. I think the pure lesser included to attempted murder would be attempted aggravated assault. Because it's not a murder charge, it's an attempted murder. So the charge that
Attempted aggravated assault.
attempted aggravated assault. I think that what Your Honor is referencing.
But you have here a charge of aggravated assault.
I did include it all there, Judge, because I do think there's a rational basis in the record for it. But I think because that goes to the
But
substantive
hold on,
offense.
but with regard to your request for a charge of aggravated assault, obviously there are different states of mind for aggravated assault. You're not asking for an attempted aggravated assault, you're just asking for the aggravated assault.
Well, just the way that the
'Cause
aggravated assault charge reads.
It talks about attempt,
Includes attempt.
right,
So
it's
there's not a
included,
separate,
right.
But I
So,
think that if, in terms of being intellectually candid, the true lesser included, or the pure lesser included to attempted murder would be attempted aggravated assault. It would be an attempt theory of aggravated assault.
attempt to cause serious bodily injury to another.
Yes. It wouldn't necessarily encompass as a pure lesser included the actual commission, whether it's purposeful or reckless or knowing, as Your Honor just discussed. Now, I think there's a rational basis for it in the record, but I don't think with the way
I know, but
lesser included's
wouldn't
worked, that I'm in a position to ask the court to give that.
But you want the court to charge aggravated assault as a lesser included as to both Lauren Kanarek and Robert Goodwin.
On an attempt theory.
Right, so the only charge would be if they find not guilty on attempted murder, then they would consider the lesser included offense of aggravated assault, but only that he attempted to cause serious bodily injury to Lauren Kanarek and then in count two, Mr. Goodwin.
Yes. Again, unless.
Not the purposely or knowingly and not manifesting extreme indifference to human life, but
I think
what
that would be a question
what
for
if
the
they
court
find,
and the defense.
I know, but what if the jury finds that he went there not with the conscious object to kill either one of them, right? Didn't have the conscious object to kill them. But they find during the incident he did take out the gun and shoot Lauren Kanarek and shot at Mr. Goodwin. Couldn't they find, even though it wasn't his conscious object to kill, that he purposely or knowingly pointed the gun and pulled the trigger and tried to cause serious bodily injury if it wasn't his conscious object to actually kill them? I know it's splitting hairs, but
And I'm not
juries
trying
have
to
split hairs in the past.
Well, I'm not trying to argue with the court about your rationale. I'm just saying I think based on the way the indictment is reading, or reads, it's an attempt theory. So as a pure lesser included, I can only ask the court to charge on something that's fairly included in the indictment, which I think would include attempt. So I think there's definitely a rational
So your
basis.
position is if it's an attempted murder charge, it's not rationally included in that charge all of the aggravated assault states of mind, only the attempt, and that it wouldn't be purposely or knowingly causing bodily injury or recklessly.
Well, not that it's not rationally included, just that whether or not it's fairly included, I don't want to run into a potential issue on appeal.
Right, no, I
And I
understand.
asked you to include something that wasn't fairly included in the indictment. So
All right, so
I
you're
don't
not asking
disagree.
it, so Mr.
I'm not
Belinkus, do you want, what's your position with regard to lesser included offense of aggravated assault?
I don't want them included.
You don't think they're rationally based in the record? In other words, some of the evidence, you don't think a rational jury could find charge of second-degree aggravated assault as opposed to first-degree attempted murder?
That's the same theory that I've discussed with regards to self-defense, which you've rejected.
I don't understand. We're talking about the defendant's state of mind with regard to, I don't see how self-defense is any way connected to the lesser included charge. Question is, what was his state of mind at the time? Because you've introduced significant psychiatric evidence regarding the defendant's state of mind. And in fact, I believe one of the witnesses even mentioned on the stand the term diminished capacity. May have been Dr. Simmering that actually mentioned that term, and there's,
No, I believe that was Dr. Schlesinger, that he ruled that out. I don't believe Simmering did mention
well, I think it was before Dr. Schlesinger.
Not to throw a wrench in this, Judge, I actually think all the doctors mentioned it in the sense that they had previously evaluated people and given opinions about diminished
No,
capacity,
but
insanity, competency.
I know, but I remember a specific reference, I'll check my notes. I believe it was Dr. Simmering that actually used the term diminished capacity. I remember hearing it, partly because I was listening for it. And in these cases, there's case law when, if insanity evidence is presented, the jury could reject insanity, but still find that the defendant, because of mental health issues, could not form the conscious object to kill someone. And that would be the diminished capacity. And it would reduce the crime. It's not justification. Right? Doesn't remove all legal responsibility like insanity does, but it reduces the charge from a higher level, which has a specific state of mind of conscious object, the intent to kill. And that diminished capacity reduces the crime to a lesser crime. And it could be, there's case law, and I'll look for it, I remember reading it, that talks about specifically, if he couldn't form the purpose or knowledge to kill, a jury could find that he acted recklessly in shooting the individuals. It's a different state of mind. But under the circumstances, diminished capacity, that he recklessly committed the shooting. And the jury, if they think he had a diminished state of mind and couldn't form the intent to kill, they nevertheless could find, brandishing a firearm with that circumstances and all the tension and the toxic environment was reckless.
I agree that the law says all of that, Judge.
Right. Well, I guess the question is if there's an aggravated assault charge as a lesser included, you're saying just logically it should be just the attempt to cause serious bodily injury, from your viewpoint?
I think that's the only lesser included that would be fairly included within the
In the
attempted
indictment.
murder as a lesser included.
But if the court decides to charge the diminished capacity, there would be another possibility that a jury could find, notwithstanding what's included, that based on the diminished capacity evidence, that the defendant acted recklessly under circumstances manifesting extreme indifference to the value of human life, recklessly caused serious bodily injury.
And I think that's where the cases, Judge, talk about whether there's a rational basis in the record or not. For the court to find, and I'm just looking at 2C 1-8 and some of the comments there about submission sua sponte by the court, where neither the prosecution or defense requests a lesser included offense charge. The facts of the case clearly indicate there's a rational basis for the jury to convict on a lesser included offense that must be charged by the judge even without a request. I think that's where Your Honor is,
Yeah.
what Your Honor's indicating, which is why I'm not taking a position one way or the other on that.
All right, Mr. Belenkas, what's your position with regard to the lesser included offenses, both as requested by Mr. Shellhorn with regard to the attempt to cause serious bodily injury as being included in the attempted murder charges in counts 1 and 2?
Does that state my position right?
I'm not sure I understand it.
I don't think they should be charged,
Why?
because I don't think the evidence before the jury addresses that issue. Either he went down there with the intent to kill them and is guilty of attempted murder, or he's not guilty by reason of insanity.
What about if the jury rejects insanity but finds that he couldn't form the intent to kill? You're saying I shouldn't charge aggravated assault, that he acted recklessly because of his diminished capacity?
The only
I'll consider the positions of counsel. The state requests a lesser included on counts 1 and 2. On counts 1 and 2 of second-degree aggravated assault based on attempt to cause serious bodily injury.
Yes, Your Honor.
Okay. And that's really without regard to the diminished capacity.
Correct.
The defense doesn't want any lesser included offenses. Is that correct, Mr. Belinkis? And that's part of your strategy in this case? It's a strategic decision on your part, correct?
I don't believe it's a strategic decision. I don't believe there's evidence in the record to support that.
All right. Despite the mental health evidence presented by your experts, you think that can only be used by the jury to go into insanity and not to consider lesser included offenses?
Yes.
You have any case law that supports that position?
No.
The court will give, I'll make a decision either later today or over the weekend on those lesser included offenses. I will give the standard charge on insanity from the model criminal jury charges. And in the model charge, it specifically references the 3 verdicts. In the charge, you may return 1 of 3 verdicts: 1, not guilty; 2, guilty; 3, not guilty by reason of insanity. Well, that's the order I'll maintain on the verdict sheet. And I'll do further research on the charge related to evidence of mental disease or defect, that is, diminished capacity. And that's set forth in Criminal Code 2C:4-2, evidence of mental disease or defect, admissible when relevant to element of the offense. Evidence that the defendant suffered from a mental disease or defect is admissible whenever it is relevant to prove that the defendant did not have a state of mind which is an element of the offense. In the absence of such evidence, may be presumed that the defendant had no mental disease or defect which would negate a state of mind which is an element of the offense. Mr. Shellhorn, do you have a position with regard to the so-called diminished capacity? Or do you want time to read that section?
No, Judge, I'm familiar with it, and certainly if Your Honor is comfortable that Dr. Simmering testified to that. I was also listening to it, or for it. I don't recall hearing it.
I'm not even sure he has to specifically say that. Because it says evidence that the defendant suffered from a mental disease or defect is admissible whenever it's relevant to prove the defendant did not have a state of mind. A relevant state of mind. So in other words, my view is a jury could find that Mr. Barisone was not insane at the time, legal insanity. And therefore, they're not going to find him not guilty by reason of insanity.
I think.
But then the question is, are we going to preclude the jury from considering his mental state in light of the testimony from the doctors?
I think the issue that I am having with it, Your Honor, is that none of the doctors testified that the defendant recalled or was indicated anything about the circumstances of what he was thinking at the time, which I think would be the direct question Your Honor's asking, whether he was acting purposely, knowingly, or recklessly. And so if all the doctors say we either asked him or didn't ask him, but we have no way of knowing why he did what he did, then I don't know that they could really opine that his state of mind or ability to form a purposeful or knowing state of mind was affected because of his mental health issues or his diagnosis. As compared to, for example, if the defendant were to have said, I went there, I had the gun for self-protection, I saw the look on someone's face, and that led me to believe delusionally they were going to kill me, and so I acted. That may have affected the doctor saying, well, that was not a purposeful state of mind, it was a lesser state of mind. I think maybe that's the part of the psychiatric testimony that is missing to me, that would support a diminished capacity. And not to belabor the point, Judge, but I think that both Dr. Simmering and Dr. Simmering and Dr. Hassan testified that the defendant's delusion was that he was going to be killed. He went there in an effort to act in self-defense, which I think what they're saying is that that would indicate a purposeful state of mind. Perhaps purposeful and justified in the way that they're saying it, but purposeful as opposed to something else. And because there's no statement from the defendant that could be interpreted differently in that regard, but I could be reading it too literally.
All right, Mr. Shellhorn, I think in your comments, whether you knew it or not, you were referring to State versus Rivera,
What page are you looking at, Judge?
228. It says, when there is no request to charge diminished capacity, and there's no request from the defense, and no part of the psychiatric testimony referred specifically to the effect of the defendant's mental condition on the ability to know he was committing murder, there was no need to charge diminished capacity.
I was actually almost reading that exact line when I was just talking, Judge, yes.
Right.
I didn't realize that was a citation, but yes.
I'll have to review my notes regarding the witness testimony, but it's your recollection that none of the doctors opined on his ability to know he was committing murder.
That was my recollection, yes, Judge.
All right. Do you have it?
It's mine.
All right. All right, I'll review the evidence. And Mr. Barisone, are you in agreement with your counsel's position?
Whatever Mr. Focus says.
All right. Well, have you discussed it with him in detail about
Yes.
the charge of diminished capacity?
Yes, he's informed me, and whatever Mr. Focus says is what I go with.
All right. The reason why I ask that, because if I don't charge it and the jury doesn't accept insanity, they may convict you of attempted murder, which obviously is a higher charge than the second-degree aggravated assault.
Yes, sir.
All right, I need to do a little more research on the issue, but I have the position of the parties in that regard. I think that's generally it. I'll give the standard charge on deliberations, unanimous verdict, go over the jury form, jury questions, things of that nature. All right, anything else, counsel?
Judge, I think you mentioned this, and then we started talking about the lesser included offense, but you're also going to just give the standard charge on possession of a firearm for an unlawful purpose,
Yeah,
and do it the same way as the
yeah.
attempted murder.
I'll reference count 3 pertains to unlawful purpose to use it against Lauren Kanarek, count 4 unlawful purpose to use it against Rob Goodwin, and I'll give the standard charge.
Judge, on page 5 of the standard charge, it talks about the allegation with respect to the defendant's unlawful purpose. It says, in this case, the
Is
state
it-
contends that the defendant.
The second, what do you,
I'm sorry,
all right, so the first element is that exhibits whatever is a firearm. What's the specific exhibit that I'll reference?
I think it's 177, Judge, that's 177.
Okay. All right, so the first element is the firearm, exhibit S-177 is a firearm. The second element, the defendant possessed a firearm. Knowing intentional control, so define knowingly what knowledge is. And possession means a conscious knowing possession, either actual or constructive. Yes, in this case, the state contends. And what was your point in that regard?
Judge, I had suggested in what I submitted to the court previously that the defendant's purpose in possessing the firearm was to use it to shoot Lauren Kanarek and/or Robert Goodwin.
Mm-hmm.
that was the only place really that called for any suggested additional language. I just
Okay,
wanted to point
all right,
that
we'll
out.
just make reference to that, the purpose to use it to shoot Lauren Kanarek as regards to count 1, and shoot Robert Goodwin as it pertains to count 2. All right. Anything else, Counselor, you want added?
I don't believe so, Judge, no.
All right, Mr. Belinkus?
Just for the record, so it's clear, I did ask for a self-defense charge. I've made my arguments numerous times. I know the court's rejected, but I just want to part of the record with regards to charging.
Well, just so the record is clear, since we're having a charge conference, what is your basis for asserting that self-defense through the use of deadly force should be charged to this jury? What evidence in the record can you point to?
I could point to the severe beating that Barison suffered at the hands of Kanarek and Goodwin. I could cite to.
And what evidence is there that occurred prior to the shooting, and that Mr. Barisone utilized the gun either during or after the shooting, the beating, to protect himself?
As I have previously indicated, the only evidence with regards to the timing of the shooting comes from both Kanarek and Goodwin. I believe there's ample evidence in the record that both of them have lied with regard to this incident. Their testimony, I submit, is completely improbable and nearly impossible to have occurred the way that they said. And again, based on that, and again, if the court recalls, I attempted to ask Ms. Kanarek if the beating occurred before the shooting, and was not allowed to get a response based on the court's objection. So I believe there is sufficient evidence, particularly in light of all the previous threats that were made. The incident the day before where Robert Goodwin had made a gesture with his finger at the gun, threatening to kill Michael Barisone.
And what was the immediacy of Mr. Barisone arming himself and going to the farmhouse? Because this is deadly force, right? And there's got to be a reasonable belief that force is necessary to protect himself. And you have an individual who arms himself and drives to a location a quarter mile away from the clubhouse, armed with a weapon. So how is there a reasonable belief on his part that force is necessary?
With all the threats that she had made leading up to that, all the social media posts where she threatened to kill him and Mary Haskins, it could be argued that he believed it was necessary, if he was gonna have any contact with her, to arm himself.
What was his purpose in going there? There's nothing on the record about that. You want the jury to speculate about why he went up to the house that day?
No, he went there to try to work this out. He said specifically, can't we work this out?
I know, and where is that evidence from?
It's from him.
How is it from him? How is it from him?
That's from Robert Goodwin and Lauren Kanarek.
Right, their testimony, so that part is accurate, but what follows is not, in your view.
Judge, witness can lie about different portions of their story. He certainly didn't come down, and say anything threatening according to them. She, and the testimony is clear, she came out, she was angry, she approached him, it's been described as her stomping towards him. And again, it's my belief that their testimony is not going to be believed, and I think it's appropriate.
Mr. Shellhorn?
Judge, only if you need to hear from me.
No, I don't think there is sufficient evidence in the record for a self-defense charge in self-protection. First, the defendant armed himself, according to the evidence, from a weapon he obtained on the 2nd, I believe, so 4 or 5 days before. And when the DCP&P worker came, she testified that Mr. Barisone came into the room where she was talking to Miss Haskins Gray on 3 separate occasions. There was no cross-examination of that witness by Mr. Belinkus, so her testimony is essentially unrefuted. And that, it's unrefuted.
I don't believe it's unrefuted because the medical experts all testified.
That's not substantive evidence. You can't argue that. If you're planning on arguing that in summation, don't even put it in your notes. It's not substantive evidence. Mr. Barisone's statements to the experts, I went over that charge. They are not substantive evidence. You cannot use his statements to make any substantive arguments to the jury. They only go, and they're only admissible as it pertains to his state of mind as determined by the experts. That's what the charge says. You cannot use Mr. Barisone's statements to experts to refute the testimony of the DCP&P worker. That would be using the evidence substantively. It can't be done. It's not proper. And that's why I said the testimony is unrefuted. There was no cross-examination. And the witness said, Mr. Barisone came in 3 times, asked them to leave. On the 3rd time, he was insistent. The worker even said Mr. Barisone kissed Miss Haskins Gray when they were leaving the room. And the clear import from that testimony is that he wanted to retrieve the gun because he immediately left, drove up to the farm while armed. And then there was a confrontation. Mr. Goodwin spoke to him, and then Ms. Kanarek came out. And even if the jury doesn't believe everything that Ms. Kanarek or Mr. Goodwin said about the incident, they would be engaging, in this court's view, in sheer speculation to determine that the beating happened before the gun was withdrawn and that Mr. Barisone withdrew the gun as a result of the beating and used it in self-defense. That would just be pure speculation. There's no evidence in the record. And even through cross-examination, that was to impeach their credibility. So, to the extent that they were impeached does not mean the jury has evidence from which, in the record, from which they can rationally find that the beating happened before and that Mr. Barisone took out the gun because he believed, reasonably believed, he was in imminent danger and needed the weapon, that it was necessary for him to shoot twice at Ms. Kanarek in the chest to protect himself. And it's even further speculation, given the nature of the testimony, that he took a shot that went through the porch door and into the house. A jury would have to speculate as to the reason for that shot being fired. Without the testimony of Mr. Barisone about the incident, there's simply no evidence in the record. And it's not sufficient for the jury to make that determination simply from the cross-examination by Mr. Belinkus. There's simply insufficient evidence in the record to support the self-defense charge, so it will not be given. And I might say the self-defense charge would be contrary to the testimony of Dr. Simmering, the defense expert. We found that the defendant's need for self-defense was a delusion on his part. I do find there's no substantive evidence in this case to support the thesis that the defendant acted in self-defense. It would simply be speculation by the jury, so it won't be charged. All right, anything else?
Oh, yeah.
All right, thank you. I'll try to finish this by this afternoon and send a charge to you for your review over the weekend.
Your Honor, before we go off the record,
Yes,
I just wanted to mark for the record defendant's proper exhibit number 8, which is that safe sport document that Mr. Belinkus was allowed to use yesterday. And mark for the record, it's in the proper, the handwritten notes, Mr. Barison, 900E3.
what's the purpose of marking that document?
Just because various things in there I was excluded from getting into, and I just want the record to be complete.
Which specific things?
About Michael Barisone knowing that Robert Goodwin and Lauren Kanarek were searching or trying to contact the small children prior to the shooting on social media.
All right, well, that document, the problem with that document, it was drafted after he was incarcerated, after discovery had been turned over. So the fact that it's in a document doesn't indicate Mr. Barisone knew it beforehand.
Judge, I understand the court's ruling. All I'm doing is trying to make sure the record knows exactly what was in it in case there's any issue.
Well, what the record doesn't show is when exactly that was drafted. I think we, are you in agreement that it was drafted after Mr. Barisone, after the shooting, not before? And after he was incarcerated?
It was drafted after he was incarcerated, obviously, and it was drafted at the behest of Dr. Simmering, so he can use it to do his evaluation.
Your Honor, there's some other photos we want to move in evidence.
Yes. What are the numbers?
So the first one is 800-92. It's this, we only have a small copy of it. It's the, you want to come over and take a look at it?
What witness was that shown to? I don't remember witness seeing a small photograph.
Judge, these are the photographs that were done of the crime scene, and I was under the impression that we were stipulating to all these things.
I don't necessarily have an objection to the photo if it was shown to a witness, but I just don't recall a witness.
If it was shown to a witness, that's fine, but if it wasn't shown to a witness, it's not going in. There still has to be some testimony about it. Let me see the
Again,
photograph.
it's really, it's a close-up of one of his pictures, Judge.
We agree that these already came in 53, yeah, 55, right? That one, and those all got passed around. Yeah. Did you? Because I want to make sure they have it clear on the record.
Do you know who he's connected?
One of the doc, one of them that, I think we put it all on the record and we moved him in, that's the only reason I could show it to the jury. So, that's all, I'm just checking that it was, I thought there was only 4, so that's the only reason I'm checking. Well, that's possible, whatever has been moved in, I'll double check, we can agree on that later on, right?
Here, here's the top.
Okay, so we got it.
52, 55,
Yeah. And then, here it is.
54, yes.
Let me write this down. I have 52, 55, 54. What were those numbers, Sally?
52,
Uh-huh.
55,
Yeah,
64,
yeah,
66,
yeah.
56.
Okay, that's all I want.
And they were 3 sellers.
Yeah, no, I'll pick out the right ones, we don't need to do this, I just wanna confirm that they're right. Thank you.
Was there any other ones?
No, not at this time. We already talked, we moved this one in yesterday, that Lauren Kanarek marked one.
Right.
Yeah, but that's all you guys have.
But it was the 4 pictures.
Well, I also moved in evidence this one of the warrant. I'm gonna check whether 500 dash 5 is moved in. Wanna check on that. Lopez. No, it's Lopez.
Yeah.
Yes. Yeah, so 5.
You have that,
Great.
Alex?
505,
Yep, all right, great. Thank you. You already think we've resolved those issues?
Yeah, so my position on that picture at the bench, Judge, is that if there was testimony about it, I don't object to it, and if I may approach.
Mhm.
This is, just for the record, it's 892, 800-92. If there was testimony on that, I have no objection to it.
Judge, it was my understanding that I stipulated to all the photographs the prosecutor needed to introduce, and they were in the same stack, and it was my impression that I would be able to put that in without calling names. And it's virtually a picture that's a close-up of one of his shots.
But I hesitate to admit it if it wasn't shown to a witness, even if there is a stipulation, because they would have to identify it or give some testimony about it.
I think that's where I'm coming from,
Right.
Judge, is that,
I wouldn't ask for any testimony, Judge, just if you take this picture, does it accurately depict it?
I know, but still, it's part of, it's part of the trial record. If that's in evidence, then there's no reference by any witness to the photograph.
right, I don't know how, in other words, I think, Judge, the jury would have to have some testimony about what the picture is and what's going on in the picture,
Right.
which is what I did with all the
Right, they
pictures I
were
showed.
shown, they've seen it,
Right.
moved in evidence, and the other ones regarding the injuries were shown to the jury, they saw all those. This was never shown to a witness or shown to the jury during any part of the trial, so I don't think I can admit it for that reason.
I just asked that it be included with these other documents, Judge, as part of the record.
Sure.
See you on Monday.
Thank you, Your Honor.
And can I see those other photographs? So I know what is being admitted for the record. I need all the numbers. My staff needs the numbers too.
So, may I approach?
Just read them out for the
One is
record, please.
800-3. Another that was admitted is 800-42. 800-52. 800-56. 800-66. 800-64. And 800-55. And lastly, Your Honor, Defense Exhibit 500-5, which is a notice of violations.
500-5?
Yes.
I believe that's all correct, Your Honor.
All right, those are all admitted in evidence. Yes.